SEC versus Ripple, case explained in detail. Ripple, the company behind XRP, the native cryptocurrency to Ripple blockchain, has been accused of raising over $1.3 billion through illegitimate means in the SEC lawsuit filed on December 22, 2020. The plaintiffs are seeking for Ripple's token to be considered a security rather than a currency in US, stating that this change would result in similar tokens also being classified as securities. This case is important because it will set legal precedent worldwide, not only for investors but blockchain innovators and lawmakers as well. Ripple Labs Incorporated was sued because they sold XRP tokens and raised $1.3 billion between 2013 and 2020, while there were no indications that Ripple Labs was being monitored by the SEC at the time. Later in 2020, when they did file a lawsuit against Ripple Labs, Larsen and Garlinghouse had already pushed their token sales across numerous exchanges worldwide with help from market services provided for non-cash transactions where more than $100 million worth of XRP were paid in to promote these sales. The SEC believed that this violated securities laws as it wasn't registered security but offered to investors globally despite not being a registered security or even legal tender under any jurisdiction's law. The SEC has filed a complaint against Ripple's CEO Brad Larsen and CTO Jed McCaleb for failing to register their offers and sales of XRP. The complainant is alleging that the defendants sold approximately $600 million worth of XRP, despite knowing it was in violation with federal securities law. How did Ripple respond? The SEC received no response from Ripple Labs for 39 days. However, the blockchain company quickly took to Twitter to clarify the company's position, purge its image and maintain investor trust. Garlinghouse proclaimed that the SEC's battle was not just against Ripple but the entire blockchain industry. Garlinghouse went on to counter-allege that the SEC hand-picked Ripple Labs for direct scrutiny, and that they should not be able to cherry-pick what innovation looks like, especially when their decision directly benefits China. He also wrote a blog post elaborating on how Ripple worked with the SEC in order to avoid regulatory infringements. He even explained this matter of interest at length for Ripple Labs employees, who were informed XRP was not an investment vehicle but just a token holder. If they wished to become shareholders in any way possible, it would have been necessary for them to purchase company shares instead of investing in XRP tokens. This sets a terrible industry-wide precedent for any company working with a digital asset. With this allegation, coupled with the SEC's Good Housekeeping seal of approval bestowed upon ETH and BTC only, directly benefiting China, they're creating an unfair advantage to companies here in the US, and dramatically benefiting BTC and ETH, states another blog post on Medium. It's just incredible that the SEC, a US regulator, is in business of picking winners in this industry, or really any industry, while disadvantaging companies here in it. Ripple CEO Garlinghouse had stated, "We are not only on the right side of the law, but we will be on the right side of history." Furthermore, he mentions that their influence in US investors is minimal and that this 5% does not affect regulation. Ripple Labs just filed its official legal response to the SEC. In a 93-page long document, it cited 4 counters. 1. XRP does not qualify as an investment contract as Ripple Labs never entered such contracts with its investors in the first place. Moreover, since XRP is a virtual asset that remains outside of the SEC's purview, they have no power over this matter either way. 2. The SEC is out of step domestically and globally as no regulator mentioned that a virtual currency like XRP must be registered with them if any complaint was filed before this one happened, in order for them to provide some sort of clarity on their own about security laws, which means you are still left without any clarity from these regulators whatsoever. 3. The SEC is picking winners and losers as it said that Bitcoin, Ethereum and Ripple are not securities transactions. That means XRP cannot be discriminated against. 4. The SEC has distorted the facts as they have interpreted and presented statements out of context. In a letter to employees, Garlinghouse wrote that he will prove their allegations false in due time. The final verdict in this immensely followed case is yet to be released. However, the decision will reveal how regulators in the US view innovation in blockchain technology. If they rule that Ripple Labs violated regulations, blockchain development may slow down or even come to a halt and interest may wane amongst crypto protagonists. However, if they decide it was not an infraction by Ripple Labs, then less stringent regulations would apply, which could lead other nations taking cues from America on how best to handle innovations like blockchains, as well as causing more people worldwide are likely interested in what's going on with technologies like blockchains for themselves too. If you learned anything new by watching this video, I would really appreciate you giving the video a like. You can also press the subscribe button and turn on notifications to be notified as soon as I post the latest updates on the Ripple lawsuit. Subscribers will have a chance to participate in an upcoming giveaway of 500 XRP tokens. Stay tuned for more details. Thanks for watching and take care.